It's awesome to have you. Join us on a fresh edition of Law and You, where we x-ray society issues and giving it a legal perspective, how the law applies to these issues, to this phenomenon or concept, and how gray areas can be cleared. On today's topic, we are looking at the enforcement of age limits on marriage in Nigeria. You agree with me that if we go from the north to the eastern part and the western part, or the southwest, south of Nigeria, there exists disparity in different types of marriages or customary marriage in the whole, and the need to really clear the gray areas in this disparity concerning age limits that seem to be a controversy in marriage in Nigeria becomes the pivot upon which we are really bringing out this edition. My name is Philip Omo-Gupon, and discussing this with me, I have a custodian of the law who's going to do nitty-gritty to the law as it applies to this societal issue, and he is Alego Joseph. Good to have you join me, Alego.
Good afternoon and welcome to Law and You on ITV. It's a pleasure having me on the studio, and you're welcome, all viewers at home and wherever you're watching us from, all over the world.
I think it's good to start from this point for everyone to know, in terms of what the law is like concerning customary marriage. Do we have a law, or does the Nigerian law prescribe age limit for customary marriage?
Yes, there's actually a law in place. And before now, everything in relation to marriage is governed by the Marriage Act, and it is expected to be that that one comes under the influence of those who are mostly amenable to monogamy, one man, one wife. But we have the traditional institution that subscribe to polygamy, more than one wife, and then we have our Islamic brothers and sisters that have their own arrangement where you can marry up to 4 wives, as allowed by that religion. So, but when it comes to the child, the aspect of the child is not taken as an adult, and so anything that brings the child into that sphere of marriage is curtailing, that very opportunity or life stage that the child is supposed to enjoy, which is the time to learn, the time to play, and the time to grow. The child is supposed to explore until maturity, when he can make, informed decision for his or herself, and then be incorporated into the institutions of society for which marriage is a part. So, but when that doesn't happen, it's like giving an immature person or bringing an immature, person into an institution that is supposed to function as a mature. So it's like you are giving the child too much of a load to carry that is not ready as at yet to carry. He may have all of the features of an adult, but when it comes to maturity, when it comes to what it takes for all the physique, the psyche and all the functions of that make up his component as a person to function maturely in that institution of marriage, it doesn't have it. And so you are scuttling, or you are more or less bringing a disservice into what the child is supposed to, the role the child is supposed to play within that institution of marriage.
Okay.
So that is why it is not only marriage, child marriage that is criminalized in the Child Rights Act. Even betrothal is also criminalized.
It's also criminalized?
Yes.
Okay.
Section 21 and 22 of that law, marriage in the Child Rights Act. But as it were, it has not been domesticated or brought to bear in alignment with all the laws of the states in the federation. It is a national law made by the National Assembly. That's the Senate and the House of Reps.
Okay.
In 2003, it was brought into fruition as a law that should have effect on the nation. And whenever the National Assembly does a law, it has primary effect on the FCT as the seat of power.
Okay.
And then other states, the legislative arm of other states are supposed to bring it, by way of adoption and, incorporating into the state's law so that it can have effect because of doctrine of federation. We are federating units, and so every state is supposed to have its own autonomy. And then it brings it into being, into function by what? Adoption, so that it can have effect on its own state.
Okay.
So as we speak, it doesn't have a national coverage. A lot of states have, adopted and brought it to be a part of their own laws, but we still have some states. The recent state that, did that was Sokoto State in November 2021. So we have several states, especially in the north east, like Borno, Adamawa, Yobe, Gombe, Jigawa, and several others, a few others in the northwest, like Kano, Zamfara, Kebbi, that have not, implemented it. That is by bringing it into their own laws,
okay,
as part of the laws that should find expression in the state.
Okay.
So when that is not done, they are kept in limbo, so to speak. That means they are aloof from what is happening in other parts of the country in relation to granting these children or these persons, what is supposed to be their own benefit by the coverage of this law. That is a Child's Rights Act, as it were.
Okay, you spoke about the Child Rights Act, and I was really coming there. But let's look at what feeds into the predominant occurrence of having child marriage, in Nigeria. Now, you agree with me that we have different customs cutting across the federating units, like you even made a mention of. And basically, feeling on that, there seems to be this disparity. Like we have the Eastern Law of 1956 governing marriage, where it prescribed 16 years as an adult age for marriage. But don't you think this disparity won't augur well for our legal system in this regard?
It's one of the quagmires, so to speak, that is being encountered when it comes to implementation. Not even enforcement.
Oh, yes, enforcement.
Yes, because we're talking about enforcement of the rights of the child in relation to marriage. So when it comes to enforcement, some of these disparities in our laws creates problems. Because when you talk about maybe like the Children and Young Persons Law, a child is supposed to be from cradle, let's say, to age 14. Because from age 14 to about 17 or 18, thereabout, is supposed to be a young person, not a child. But the Child's Rights Act makes provision from cradle to 18 as a child.
As a child?
Yes. So if a person is not up to 18...
Or from cradle to 17?
Yes.
From 18 is an adult?
Yes, from 18 is an adult. That means by the time you strike your 18th birthday,
you
can be referred to as an adult.
Okay.
So, but prior to that, you are a child. And when other laws are saying, okay, maybe like the Constitution now, for instance, okay, if you have to say, okay, this is a child, it's not supposed to go into marriage. The Constitution seem to bring in a regularization that once he's married, he's taken to be an adult.
Yes, exactly. That's my point, because that's where I'm seeing controversies, in the laws, because you spoke about the Child Rights Act, that seemed to prescribe from cradle to 17 plus, as long as you've not hit 18 as a child. Okay. But once the child hits 18, it's not regarded as a child anymore, but an adult. Now, we also have other laws, like the provisions in the 1999 Constitution of Section 29, subsection 4A and B, that said if a woman, is seen as married, the woman is deemed as being of marriageable age, of being an adult. So the onus now lies in what age does the Constitution see as an adult?
You see, the legislature is given powers to make laws for the good governance of the nation. So we give them, it's actually the people that have those powers because they are representing the people. And so when they sit there, they are sitting in favor of the people. But the Constitution, being the ground norm, is even the creator of that legislature. So they are supposed to be amenable. So whatever is inconsistent with the Constitution must give way to the Constitution.
Must give way?
Yes, as a supreme law. And that's why you see when sometimes laws are made from state legislature and all of that, and it runs contrary to the constitutional provision, even if it is made by the national legislature, that is the National Assembly, and it is contrary to the provision of the Constitution, it will be struck down. It can even be challenged in the court. They say, no, these laws you have made, though you are elected to make laws, is contrary to constitutional provision. So to that extent, it must go down.
Okay.
Or you now begin to do what we call pick and choose, or maybe strike out sections of the law that offends the provision of the Constitution, if you want to give life to such a law or such an act of the National Assembly. So once it runs contrary to constitutional provision, it's like an effort in futility. Your hands are tied, as it were. There's nothing you can do, except the National Assembly will go back using its powers to think out the provision of the Constitution, to bring it in line with what is they are intending to be the picture or the scenario within the social milieu. Because the laws are made to function with the people, and the people function in a social system. And if this thing doesn't come in place, in a way that will fit into the structure of the society, you discover that they will just be locked up there in the books, not having any bearing with what it is intended to, the change it is supposed to bring, or the transformation within society.
Okay.
So what's the essence of making the law? When they remain in the books, it's like a wasted effort. So what you do is to, bring the laws in tandem. If there are other laws, that are conflicting with it, or you bring all of them in place, especially the Constitution, which is the ground law, which is the supreme law, as it were, of the land. So if the Constitution, you are here busy doing other things, and the Constitution says no, or what you are trying to curb or to cure, the Constitution have regularized it in a way or approved it in a way, then you are more or less wasting your time with all of these efforts.
Okay.
But it is not totally wasted, because activism, the functions of awareness, enlightenment, can begin to make the social order tilt towards a reaction for change.
Okay, let's look at the other perspective where arguments like these can be tested in the law courts to determine which way to go, as per the age limit for marriage. Can we say we've had enough testing of this argument in the law court?
We will not actually have such testings.
We've not had
let me put it straight and forward. Because one thing with the court is that they take judicial notice, when matters begin to come up in the courts and all of that, and people are trying to, square up with the rights that have been provided in the law. Even the judges and their justices, their lordships will begin to take notice of these things. And then the system too is beginning to find a way to measure up with what the law has provided. Come to think of the issue of bigamy. It's in our laws. It is criminal. But how many women have taken their husbands to the court for flouting that law, for violating that law, and saying, okay, we are supposed to be in a monogamous union, but here I am finding you with another woman and all of that. I must go to court. People are just like, oh, what are you doing? Is it not just common?
I think that has a lot to do with our African background. Because
it's our orientation,
yeah.
Yes.
From this side of the world.
That is why we are talking about enlightenment.
From this side of the world.
Yes.
Because I think that's where we are also having setback, in having the federating units, keying into the Child Right Act, like you did say. Because we are having that challenge. The Islamic laws, for instance, seem not to go hook, line, and sinker with the Child Right Act.
Yes. Within their cultural milieu, up that way, you see everything rolls into one, like the educational aspect, the adoption aspect. For instance, if you adopt a child and it's supposed to bear your family name and everything, they still want that relationship where the child will be tied to the family lineage from which he or she is coming from. When it comes to like this child marriage that we're talking about now, within their social milieu there, you a child, you're not supposed to question the authority of your father, even when you are betrothed, when you are giving out in marriage. So it happens. It's
which evolves from our customs.
Yes. So, but when enlightenment begins to come, like a child who desires education and he wants to be there, and he's outspoken, he wants to speak out, he wants to begin from that level in the school. You are giving the child awareness about to go, what it takes, even the health implication of going into marriage when you are not ready. For instance, cervical cancer, and all of these fistula and other things that comes with marriage in a tender age. When you begin to give the disadvantages of all of these things, being a mother when you are not ready yet. It's like going into murder because you are not ready. Instead of being a mother, you might be engaged in murder. You start to kill.
And in most cases, even the one that you are putting up in this marriage, the consent is not being sought. Like those being betrothed, for instance.
Yes, your consent will not be sought because to them it's inconsequential. It doesn't really matter. But when enlightenment comes and activity come in place, non-governmental organizations, civil society organizations begin to throw up this awareness, and then we'll begin to take it up as a challenge.
Okay, but does the law have its place in terms of preventing such, in terms of a situation where marriage is being contracted without the consent of those involved?
Yeah, it is when you see something and say something and take it up, because equity does not lie. The law does not lie on the side of the indolent. If you do nothing, so how is the law just going to come down right where you are and just help you? The law is an abstraction, and it wouldn't want an abstraction. It works within humanity, within the social order. So that is where humans will allow the law to work among. For instance, now, okay, let's say you ban open grazing, and I'm still going out and seeing a cattle or cows all over the place. That means there's no enforcement. The laws are there in the books. So if those who are supposed to do the enforcement mechanism don't come into to make it work, it wouldn't work on its own. So there must be people like, when there is an implementation committee that is just all about creating structures to make the law have a stand within governance. But when it comes to enforcement, that is where you effect compliance. You apply a measure of pressure, coercion, to make sure that everybody falls in place. So when the enforcement aspect is not done, and it is just all about implementation. For instance, there are laws on environment and all of that. If it is not enforced, it wouldn't work. Even though the implementation has been in place through creating structures and all of that, a body that is supposed to do that. If the actual enforcement is not done, then it will be left like that.
Okay.
So you can criminalize some of these things, okay, like maybe 5 years jail term or an option of 500,000 naira fine. But have you brought the person to book? So, but if it is taken as well.
But the laws have to be straightforward in that direction for enforcement to really have its way.
I'm just giving you an example. For instance, okay, maybe you criminalize open grazing.
Okay.
And there's still grazing.
For instance.
Yes, for instance. It's just an example.
Yes, and
it
it may not be applicable to
if it is
this
not,
case.
Most of the time in Nigeria, the problem we have is implementation or maybe enforcement. Okay, maybe you have maybe a law that says a particular vehicle should not carry the load that is beyond this limit. And vehicles that are carrying such load and passing by every time. If there's no enforcement, they will continue to flout the law.
Okay.
And it will look as if it is non-existent.
But who do you see that should bear the brunt of this seemingly no enforcement?
The child bears the brunt because the law was actually meant to protect the child. Because the child at that stage does not have, all it takes to protect himself or herself. To protect herself, because when we talk about most of these child marriage, it's mostly the female form, that is the girl child, that bears the brunt. Because most of the time, the boys, even if they're going to such marriage, but most of the time, they are of age.
Yes, of age, because it's mostly the female.
The girl child.
Yeah, the girl child.
So, and statistics have it that over 23 million are victims of child marriage. And it's, from the northwest, you see that is about 76%, and lowest in the southeast, about 10%. So when you look at all of these, things, and it borders the society, when we talk about enforcement, as I said, most of the time it is within the social fabric, because you can bring all of your statistics and say, okay, enforcement is going on. But within the social order, you still see it happening. For instance, you can bring all of the statistics and say, well, the economy is doing well. But if the common man is hungry, he will not believe all of those your statistics. So same thing goes for child, marriage. If you say, okay, the laws are there and it has been domesticated or it has been brought to bear in all of the states, is a child still being married off? Are you getting now? Are there still cases of child marriage going on? UNICEF will tell you, Save the Child, like a CSO and NGO, will tell you that there's still child, marriage going on. So that means what the law was created to curb or to stop is still, having its way.
Okay.
It's still holding sway within the system. So it now means something needs to be done to curb these excesses, because at the end of the day, if a child goes to marriage, maybe he gives birth to a child and he goes on and on like that, there is nothing he can do. Okay. For instance, now maybe I've been a victim of insecurity, and there's an agency or persons that are supposed to protect my right by getting me out of the captivity of those persons who have held me back, and nobody is coming for me. There's nothing I can do. I'll be left there as a victim.
Thank you.
So,
in case you're just joining us, as law and you, and the topic on the crucible as the enforcement of age limits in marriage in Nigeria, and I've been discussing with the custodian of the law, Barrister Alegu Joseph. Now, let's look at this aspect where, like you said, there has not been much testing, in the law court, to bring about a headway on how this enforcement should be like, and the different customs we have, from the north to the eastern part, south, seem to also be becoming a big challenge, and even the religious perspective also seems to be a big challenge. What do you see as a vital part that the legislature should take in bringing this adoption of the Child Rights Act, which has not really sunk into implementation among the federating units?
What you do most of the time in legal reforms is to look at loopholes. Anywhere you see a gulf or maybe a schism, the best to do is to close that gap. If you discover that people are taking advantage of this to get around, there is always something, an evil or something bad, something that is not good you want to kill or you want to curb within society. But you discover that people are using their intelligence or some of the advantages they have, some other arguments to make a fool of that provision by getting around it to still get at what they want. So you try to look at that loophole. Okay, this is the path they are going through to undermine this provision. You try to curb that access by blocking that channel. You block that channel. So if somebody is using the constitutional provision to undermine, what is supposed to be to the advantage of the child, what do? You do the needful by doing what? Curbing that aspect.
Okay, but you see,
if you want to say, okay, maybe it is regularized because the person has now become an adult, criminalize it and make it and add a caveat, or let's say a proviso that except, are you getting now? Maybe or except the person did not know of this provision or something. Couch it in such a way that it would take advantage of, you will now take advantage of what they have been taking advantage of.
Okay.
To make sure that you implement or bring to effect what you have been trying to curb, which is the protection of the child.
Okay. How do you zero the compliance of the religious sentiments into this?
Okay. You see,
because that's another challenge.
Religion has always been with us right from time. But any law or any practice that is repugnant to natural justice, equity, and good conscience, you try to do what? Curb it by way of provision. That is why the law comes into effect. If not, we'll still be having some funny traditions, like from our past where we hear about, albinos are good, they stop this thing. But it is just because of the laws of their pigmentation, skin pigmentation. So it is not, okay, maybe you look at, those who have Down syndromes and you begin to look at them as if they are full. No, it is because of a defect of birth. So you protect, when you want to protect the right of individuals within society, you must have the other opposing force or the evil force that want to destroy the good.
Okay.
So you try to enforce the good and you try to prevail with the good through what? Curbing most of those excesses. So when you say religion is all about good, right? And it is good to protect the right of the child. So by way of continuous orientation, it's just like, okay, maybe you said, okay, you are the priest of a shrine and you are allowed by African traditional religion to do what? To appease your gods and all of that. But must you use a human head? Are you hearing me now?
Thank you.
You try to cut that aspect.
You've been awesome in helping to clear those areas in this direction.
The government, the law must come in.
Okay, but before I let you go, some believe that the legislature in Nigeria seem to be pitchy-patchy in addressing this issue. Do you share in that opinion or thought?
Not necessarily. They do their job, and sometimes, is it by the benefit of eyesight or by virtue of what plays out within the system, they come to challenge their job. Finely job, neatly job done. But here you are. Somebody is telling you, well, the constitutional provision said you cannot be higher. Whatever you do as a law cannot be higher than this.
All right.
It is not that they're not addressing issues. If they are addressing issues and there is a constitutional provision to which they have not averred their mind, you go back to the drawing board.
Thank you.
And we launch.
Thank you so much, Barrister Alegu Joseph, who is also a reverend, a pastor of your
Mega Grace Chapel International.
Oh, beautiful. Good to have you join me. And we just hope that you seek another opportunity to really oblige in the next meeting we could be having.
Please, I implore you, join to protect the rights of a child. Children are our future, and if they are not there, we have no future.
All right, that's it on Law and You. We do this again on a fresh edition of Law and You next week. Goodbye.